either. I did not argue facts not in evidence. There is a lot of surveillance video and other evidence that shows the time frame. And when I referenced that rape is not about sex, it was about power. It was in reference to the acts that were testified to by Mr. McKenzie and that there was corroboration of on her. And when he physically smacked the bottom, it was not even related to any of the sexual acts. It was related to the acts that occurred during the incident, which are evidence, and it is not grounds for a mistrial.
All right, well.
Also, just for the record, there was no contemporaneous objection at any point during the closing argument at any time during which he alleges that I did any of these things.
Well,
And Your Honor, for our record, there's no foundation to show any of the clocks matched. In this case, no foundation has been laid with the surveillance as opposed to their cameras on their phone. So that is not in evidence showing that this is exactly the time that happened.
And actually, Your Honor, that is absolutely incorrect. The surveillance video shows that exactly 2:35 and 15 seconds out in the hallway, Mr. Vandenburg pulls out his phone, and we see video in the first video file, IMG_1398 and Exhibit 36D, that at exactly 2:35 and 15 seconds is when that 13-second video begins, and that actually authenticates the timestamp very precisely.
There was no foundation laid to any witness in here about the times matching.
well, I think the jury saw the time on the video and on the images, but in any event, well, as Ms. Jim Norman stated, she did not cry, and our courts have in the past allowed that, but I didn't see her cry myself. She may have appeared emotional, but I did not see her actually shed tears. So your objections are noted. All right?
Thank you. I know you said you're going to have 5 more minutes. I'm going to go to that one once more.
All right. Who's going to do?
It will be me.
Okay.
Court being 5 minutes or 2 seconds. 4 minutes. Which one? A big clip? Yeah. Take the biggest one you got.
What was your name?
Here, right? Is that holding it? I'm sorry.
Just about 30 seconds.
Okay, so some preparation here. Can they all participate in the closing, or can it only be one lawyer?
No, I mean, it's only one lawyer. And so somebody from the defense team is going to give this closing argument. I'm sure they wish they could tag team, but they're not allowed to do that. So it's only going to be one lawyer.
I see a chair being pulled up there, and Courtney Teasley, remember, delivered the opening statement from a chair, and so I see a chair there. I wonder if she's going to do it again, or if it's going to be Warwick or Kadisha Bag.
No, I mean, I think the other lawyers could aid, maybe if there needs to be pages turned or something pulled
But
up.
only one talking.
Yes, yes. You know how lawyers love to hear themselves talk. I mean, we never get through closing arguments if all of them participate, you know.
Yeah. Okay, well, we will see. Here we go. The jury's coming back in.
All right, please be seated. All right. Ms. Teasley.
I'll pick them up.
Well, ladies and gentlemen of the jury, we are here at the end. And as I told you in opening, by the end you will be overwhelmed with evidence. You will be overwhelmed with an abundance of evidence. But the state has done an excellent job of revealing exactly who the ultimate manipulator is. They've done an excellent job of revealing who the ultimate deceiver is. Oh, they've done an excellent job of showing you just who the ultimate puppet master is. We know he's only been on campus 2 weeks. He already meets a young lady who trusts him, and he gets the help of 3 younger football players to take her to the room when she is passed out from drinking too much. Now, this isn't uncommon at Vanderbilt or at any college. So, when Mr. Vandenburg and Mr. Banks are taking her upstairs, she's drunk, it's late. They're used to seeing drunk people. So nothing's uncommon about that. Nothing uncommon on surveillance until Mr. Vandenburg gets upstairs off the 2nd floor, and he's laughing because she's drunk, and he takes out his camera and begins to record. And then Mr. Banks follows suit. Now, he gets her in the room and she's the laughter for the night. And the second drunkest person is used as the entertainment. 9 photos and 3 videos from Mr. Vandenburg's phone. He's not in any of them. 9 photos and 3 videos, and he's not anywhere to be seen. Mr. Batey's in 4. 2 of the videos. All the while he's laughing, and so are Mr. McKenzie and Banks. And Mr. McKenzie carefully takes photos with Mr. Batey's phone and ensures he's only barely seen anywhere. Maybe a shoe, maybe some clothing. He's doing a good job of staying out of the pictures. Now, cameraman Banks is so busy taking pictures. He has the most on his phone, 14. Mr. Batey's in 7 of them. They're being entertained. This is funny to them. Photos, and Mr. Batey is in 12 and 2 videos being used as the entertainment for the night. The second drunkest person stand over here. A picture's taken. Push your butt in her face. A picture's taken. Now move over here so I can get a good picture.
Please, there's nothing in the record about that being stated.
All right.
There are pictures taken each time of Mr. Batey. Obviously, he can't take them himself. Each time. Now go eat your food. And then, the ultimate puppet master, he snaps his fingers and 4 other football players arrive to clean up his mess. Oh, he snaps again, and Mr. Prelude cleans up the floor. Even made sure Mr. Prelude was gone the next day so he could have sex with Miss Lackey and ensure that his sperm was found in her and ensure that there was a consensual reason his sperm was there. He snaps again, and he makes his other friends destroy all the evidence. Goes physically and gets their phone. Goes and gets their computer. All while manipulate her to tell his story of what happened. Now, the state has done an excellent job of showing you these things, because that is what he is. But Mr. Vandenburg is not in trial today. He will have his day in court. But what I promised you is that they would show you this evidence to inflame you and make you convict Mr. Batey for the actions of Mr. Vandenburg. They want you to be mad so you can convict Mr. Batey for the things that Mr. Vandenburg did. Now, the side of the state not focusing on Mr. Batey, there's nothing to show that Mr. Batey has a memory of anything. There's nothing to show that Mr. Batey has a memory of anything that happens between 1:30 a.m. to 10 o'clock the next morning. But surveillance tells a story. Now, surveillance has shown you, and Ms. Royster has told you, a drunk Cory being led up the elevator. So drunk, a friend of his told Ms. Royster to take him home. You saw him leaning in the elevator, leaning on her, leaning back and forth, and her he has no memory of any of that.
Mr. Batey, I think you're on, please.
It's Mr. Batey, yes.
Surveillance has shown him going down around 2:30 a.m. and seeing his friends surrounding a car. Surveillance has shown him falling on Mr. McKenzie for long periods of time while they're laughing. Surveillance has shown him go in the room, and then it shows Puppet Master Vandenburg covering a towel over a camera while Mr. McKenzie and cameraman Banks run up the stairs. We don't see Mr. Batey running up any stairs. Surveillance shows you Mr. Batey walking down the hallway, eating his food, getting on the elevator, being hit by the door, getting his card and scanning it, getting off the elevator, going to the left, only to go back to the right and stand in front of a door. Shows his balance thrown off, goes in a room, comes out later with a towel, drops the towel, picks it up, comes back in the room. Simple things that he did every day are the only things he did. The only things he could do. Was no running that he could do. There was not going in the bathroom, trying to figure out a way to help Puppet Master Vandenburg. There was none of that going on because he couldn't do those things. Miss Enoch filled in the gap of after, when in surveillance she was saw coming over. And she came over because she was receiving drunken texts, drunken calls, and knew this was the drunkest he had ever sounded. Now, imagine you grow up in an inner city school. You go to
a record about that either.
Right.
It's argument.
Well, but it's not in the record. He grew up and went to school.
You're able to go to a prestigious high school, Innsworth, and play football. You're a standard kid, normal issues, nothing big, haven't made any big mistakes in your life yet. You finally have graduated and you leave the nest and you get into college. First time away from home, First time away from mom's rules. First time experiencing drinking. First time drinking way too much. First time blacking out. Now, imagine the next day you wake up hungover with no memory of last night. You start to get ready for your day and you get a call that tells you you may be in a video acting a fool, acting out of character, and then they tell you, well, look in your pictures. And you go in your pictures and you see photos of a woman you've never seen before. A woman that you don't know. And you don't remember anything about that night. You see 7 photos that you didn't take. 7 photos of someone you don't know. And you immediately delete them because you are terrified of why they are in your phone. You go to your friends to see what happened because obviously they have some memory of what happened. And they don't show you any pics that they have in their phone. But they tell you a story and they say, just stick to it. Just stick to this story. You do so because you have no memory of anything else that happened. But I'll tell you who has memory, who does have memory of what happened. Mr. Jaborian McKenzie does. Mr. I lied in 4 different statements, McKenzie does. So, liar McKenzie gets an indictment. He gets indicted on these charges. And after he's seen all of the discovery in the case, all of the things that we see here, conveniently, there's a new story made up. And the new story is, blame it on the puppet. Oh, he's in 12 photos. I'm only in 2. He's in 2 videos. I'm not in any. God, I was careful that night. Once he knows he's only in 2 pictures, and he knows that nothing is on his phone, and that everything is on Mr. Batey's phone that he told you he had. He told you I had both phones. He crafts a new story. Once he figures out his prints are on that condom box, he crafts a new story. And his new story is, well, Mr. Batey shoved the bottle in her. We didn't see any of that. We saw Mr. Banks touching the bottle, and we saw Mr. Vandenburg laughing and talking. We didn't see him there. But the story now is that Mr. Batey did it. Okay, that takes care of Mr. McKenzie and one of his rapes. That takes care of him there. Okay, now I remember liar McKenzie says, I did see him have sex with her. That'll take care of the other ag rape. Even though he gets up on the stand here and says, well, I never saw his penis, but I just know it happened. I never saw his penis, but I know that it happened. Gets up here and says, Mr. Batey put his penis in her mouth or near it. That takes care of his other ag rape. Oh yeah, I forgot. Mr. Batey also put his fingers in her vagina too. All your charges are taken care of now. You can continue to play football at Alcorn and be there for your children.
Please, nobody ever testified any of his charges have been taken care of. This statement is misleading.
That is true. Disregard that.
Mr. McKenzie ensured that he would have a defense for everything that ever came up about what he was charged with. He ensured that. Now, the state wants you to find Mr. Batey guilty of counts 1, counts 3, counts 4, based off of liar McKenzie's uncorroborated testimony. Accomplice testimony has to be corroborated. You've heard none of that here today. Nothing corroborating what Mr. McKenzie claimed happened in that room. The state wants you to assume he was urinated, that there was urine and that she was urinated on. No, we've heard no evidence from anybody saying they smelled urine in her hair, her friends. You've only heard liar McKenzie get up here and tell you that. No one and no pictures have supported any of those charges, not because their phones stopped working, because they surely worked. We know that because Mr. Vandenburg made sure to take all his pictures and show his friends what was going on, bragging. Look at Puppet Vandenburg. Look at Puppet Master. I want to send you these pictures. Look at what I'm doing. His phone never stopped working. The state wants you to assume what happened in the other minutes when there's been no testimony. That the time frames even match up. They want you to assume and convict based off of an assumption of what may have happened. That's not beyond a reasonable doubt. Now, there's no sperm. There's no fingerprints. Then, they want to tell you, oh, Mr. Batey was aided or abetted by one or more other persons. It's required for aggravated rape. Aided or abetted by one or more other persons. That's the element they have to prove beyond a reasonable doubt. Knew or had reason to know. They have to prove beyond a reasonable doubt. These are things you will have in your jury instructions. They want you to assume these things. When aiding and abetting requires one to advise, counsel, or encourage another to commit a crime, Mr. Batey couldn't encourage another to commit a crime. Couldn't encourage himself to hide out of them photos. Couldn't encourage himself to run up those stairs and hide. Couldn't encourage himself to do anything. Then, the state wants to tell you, well, I need you to find him criminally responsible for count 5 and 6. Find him criminally responsible for counts 5 and 6. When criminally responsible requires him to act with the intent to promote or assist commission of an offense. And as we know, he couldn't act with the intent to promote anything. But find him criminally responsible for what Mr. Banks did. And find him criminally responsible for the pictures that Mr. Banks took. Find him criminally responsible for that. That's not beyond a reasonable doubt. There is no aiding and abetting. There is no criminal responsibility. Now, I want to show you a board of comparison. Now, had too many drinks. Had a blackout. Mr. Batey had too many drinks. Mr. Batey had a blackout. Different number of drinks, same mixing clear liquor with brown liquor over a short amount of time, both of them. Pics and videos were taken. Videos were taken of Mr. And she had no memory. Mr. Batey was seen walking, using the restroom, and he had no memory. And Mr. Batey woke up with a hangover. And Mr. Batey didn't know Mr. Vandenburg very well either. What happened during her blackout by a friend who she thought was her friend, Mr. Vandenburg, and Mr. Batey was told about what happened when he had his blackout by who he thought was his friend. Told by Mr. Brandon Vandenburg, and Mr. Batey told the police what he was told by Mr. Banks. Now, the state wants you to accept and we can accept that because we know it to be true. And if we could also accept that Mr. Batey was in a blackout because they have the same characteristics. In her blackout, doesn't remember anything to 8 a.m. the next morning. But she was walking and talking, and how is that explained? Dr. Lippman says you can do simple tasks, not new things, simple things. You might even be able to drive home if you do it all the time. Simple things you can do. And have no memory of it because it hasn't locked right here yet. It's not here in your long-term memory. Mr. Batey was also walking, talking, doing things he has no memory of because it never locked in his long-term memory. Now, aggravated rape requiring aided and abetting would be essentially the murder of sexual assaults. The lesser included has no aided or abetted. It's the only thing that separates it. And that essentially means you could walk out, be forced to have sex with a single person, and it will be a lesser charge with lesser time than ag rape. What happened is not right, but it's not rape. What happened to her is not right, but it is not rape. We know what rape is. And Mr. Batey is not guilty of that. When I sit here and I think what I would tell a first-time college student experiencing a blackout, a first-time college student making the biggest mistake ever, their first mistake being the biggest one ever, blacking out and having no memory of what it is, I would tell him, you are bigger than that mistake. Greater is in you. You are not that mistake. That is not who you are. The state has not met their burden of aggravated rape beyond a reasonable doubt. Do not be deterred by the overwhelming evidence that was put in front of you to make you angry and convict somebody. You go through. And you will know that what happened is not right, but it isn't rape. We ask you to return a verdict of not guilty. Thank you.
Y'all take care of it. I'll call it.
Thank you, Honor. First of all, ladies and gentlemen, on behalf of the state of Tennessee and the people of Nashville, I'd like to thank you for your service. Leaving your homes, your family, to come here and spend a week and have to listen to the evidence you've had to listen to is a heavy burden for a citizen to carry. And we really appreciate your service, because without citizens like you, we can't function as a society. I usually stand here, and done this a long time, as you can tell by my hair and the way I look, and talk about what are the issues. Because I've never had a case that was videoed and photographed by the people committing the crime. So what are the issues? Ms. Teasley, I might agree with one thing she said. There's overwhelming evidence. She's right about that. But then it's like, ignore that. Who can we blame? Let's blame alcohol. That doesn't really work, but let's blame alcohol. Can't blame alcohol, let's blame Mr. Vandenburg. We can't blame him, let's blame Mr. Banks for feeding the story. Or let's blame technology, like she said in her opening. If we didn't have technology, we wouldn't even be here. Blame anybody except Mr. Batey. So she goes to Mr. Vandenburg and calls him the puppet master. And that's another thing I agree with her. Mr. Vandenburg is guilty too. He's guilty in every count of this indictment. Every one of them. So was he the puppet master? What evidence do you have? Who was the first one to touch this victim, start doing anything? Mr. Batey. And what was the only thing he was told? Put on a condom during this. Nothing else was told to him. He claims he doesn't know because he, of course, blacked out. So there's no proof at all in the record of anything like that. One of his best friends said he's a leader, strong personality. Did he look like some guy that got easily led around with all he had going on that night? He's over here at one party picking up one girl, getting texted by another girl. Then he comes down and commits these crimes and goes back and calls another girl and then calls his supposed girlfriend to come over and spend the night. Does that sound like somebody in a blackout? And then she wants you to believe fantasy story of his friends. He gets these messages on his phone, a video and photographs, and he doesn't really look at them, although he doesn't remember anything. And then they come and they tell him this story, but they don't tell him what happened. They don't say, gosh, Cory, you remember doing all this stuff? This. No, they just tell him, stick to this story. And even though he must really be struggling to be so blacked out and hung over, he remembers every detail of she was muttering, she threw up on the elevator, went and got Quella. He remembers all of that. That's the fantasy they want you to believe. And then to have the audacity to Cory Batey. Sure, Miss Lack and felonies. She wasn't out walking around texting for Mexican food and doing all kinds of things. And then to sit here before you jurors, sit here for 5 days and looked at this overwhelming evidence and say it's not rape? Does she think you're blind? Say it's not rape? She talks about intoxication. Let's look. We've talked about the law a lot. Voluntary intoxication is not a defense to aggravated rape in principle. It's not a defense to counts 1 through 4. If you find those elements been proven beyond a reasonable doubt, you don't even consider intoxication. It can be a defense to counts 5 through 7. The 2 where he's charged with being criminally responsible in an aggravated sexual battery. But in that particular case, the mens rea or the intent must be shown as the person acts knowingly. That's all. Not intentionally, just knowingly. And what is knowing? The person is aware of the nature of the conduct or circumstances that exist when the person is aware that conduct is reasonably certain to cause themselves. So it's basically aware. You're aware of, you have to be aware that a crime is being committed before you can be criminally responsible for it. It's not a high standard, but you have to be aware. Now, Dr. Lippman, of course, told us that in his opinion that you'd have to be unconscious not to be able to do a knowing act. Let's look at Mr. Batey's, the evidence in this case. Jabari McKenzie, he said, yes, we were drinking in the room, and he asked Cory had something to drink. We were buzzed. Said we did this every other weekend for a year. But no, he was walking. He was communicating. Wasn't any blackout. Courtney heard. You heard her. She went up right before this incident happened, knocked on the door. He comes to the door, greets her in his boxers. She said nothing unusual about that. And you heard Quella Royster. And what did she say today? Yeah, she was asked to walk him up to the room, and yeah, she walked him up to the room. But then what did she say? I said, did you tell me yesterday once you got the room you didn't think he was that drunk? She said, yes. And what happened in the room? Said, well, he started coming on to me, making moves on me. And I told him, no, I didn't want to do that. And he stopped. He was aware. And of course, you've got him texting. You saw the text, the quesadillas and nachos, everything spelled out. Fine, he's texting that with Miss Royster. Sarah Enoch, what did she tell you? She gets a call from him at 3:30. She doesn't call him, he calls her. He says, yes, he sounded a little drunk on the phone. And then she said, well, yeah, I did email you that he was slurring his speech, but I didn't tell the district attorney that when they interviewed me, and I don't remember that or not, so it's really not evidence. She said, yes, I admitted to email, but I don't remember. And did she tell you anything about being unusual that night? About him being that drunk? Would she have remembered that? She didn't remember hardly anything about it, just a normal night, she said.
Yeah, I object to that. She did not say that. That's misstated evidence.
Said she didn't remember anything unique about it. You think if he'd been wandering around, couldn't do but simple tasks in a blackout, she would have realized that maybe? Since she'd been dating him for 2 years, I think she might have. Of course, Dr. Lippman, right, Dr. Lippman, as I told you, he says that you'd have to be unconscious not to be able to act knowing his opinion. Surveillance videos. They kept showing you that one in the elevator, but you saw him walking all around. And that time when he got on the elevator, he was able to hold food, get in his pocket, get his wallet out, swipe it, put a card back in, put that, still hold on to his food. Was he that drunk? Of course, the video and the photographs, you saw all that went on in the room. I'm not going to show them to you again. But that one, where he's balancing on one arm and doing this, I couldn't do that sober, much less drunk. I don't think too many people could. That's a pretty athletic move by someone that's drunk, isn't it? And of course, he's texting all the time. Just texting with other women, texting for food, doing all that. Is that a simple task? Not for me, it's not. Of course, he's making these phone calls. He's calling Sarah Enoch. He's calling Miss Royster. He's making phone calls, his phone. And these actions actually attack. You remember the surveillance video? Just walking down the hall. Then he goes into one room and talks to them for a while. He comes out, walks down, takes his clothes off, walks out, takes a shower, walks back in. Totally normal. That's the evidence you have, intoxication here. Other than his testimony of anywhere from 4 to 10 honey, I forgot how many, I think he said 4 today, 6 to 8 one day, 8 to 10, I don't know. But you've heard his testimony. And then the blackout. Convenient. His own expert said, well, yeah, there was this prominent medical journal that I actually peer-reviewed this article. Studies were done on blackouts, and oddly enough, in the United States, 20 to 30% of the criminals claim blackout. But sex offenders, it's 80%. 80% of the people commit sex crimes claim they blacked out.
Yeah, Jen, you haven't heard any evidence of that?
It was placed in evidence.
And then, no text messages. You saw all those text messages that were in there with his girlfriend, with his buddies, with everybody else. Did he tell a single soul? I was blacked out. I don't remember anything. I was passed out. No, not at all. Heard the question about him hearing Mr. Vandenburg claim a blackout. You heard he didn't tell Vanderbilt about it. Well, you know, I was afraid I might get thrown off the football team if I'd been drinking. That's right. You heard him already had a pending assault, failed drug test, so maybe he was worried about the football team. So you're just going to lie to the assistant dean of students, okay? Then the police show up. And do you really think when 2 police detectives come up, start talking to you, if you were really blacked out and don't remember it, you wouldn't tell it? You think you'd still be concerned about getting thrown off the football team? Does that make sense? Sarah Enoch, you think she say, well, you know, I got up the next morning, he said, who are you, or where'd you come from, how'd you get here? Anything unusual? Not that I remember. But then Quella Royster, there's little things in trials you have to pay attention to sometimes, little nuggets of stuff. There was Quella. She'd gotten into it with her roommate up there. Cory was there. She calls him the next day at 1:30. What does he say? He talks to her for 11 minutes about it, says he's sorry it happened and everything. And I specifically asked her, did he ever say to you, what are you talking about? Not at all. Not at all. He didn't say, I don't remember anything. He talked to her for 11 minutes about what had transpired at 2 a.m. before this attack. She talked about aggravated rape and said we hadn't proved it. Well, you saw vividly on that screen vaginal and anal penetration with his finger of Cory Batey. Clear, no question about it. So, count 3, that's the fellatio. What proof do we have of that? Well, you have Mr. McKenzie, and he said, I saw him put his penis in his mouth. She kept pressing. He said, well, he had his hands on it, he pushed it in her mouth. I may not have been able to see his penis, but he had his hands right there and he put it in her mouth. And then you have the picture of him sitting there, right on top of her face. You can see her hands laying out like that. He's on his knees. Now, do you think he didn't touch her with his penis on her mouth or her face? That's all that's required. He doesn't have to penetrate her mouth. Look at the law on fellatio. And you think he just hovered there an inch above it with that photograph? Of course not. Mr. McKenzie told you that's what he saw. The photograph corroborates what he saw. And after that, what did he do? He went back to have vaginal sex with her again, indicating that he had possibly gotten some type of erection from placing his penis in her mouth. Count 4, vaginal penetration with his penis. You saw the video. You saw him making sexual motions. You saw where his hands were in relationship to her vagina. I submit that alone. He doesn't have to have an erection. You read the law, it says the slightest penetration is sufficient. Got a lot of guys on here, so I guess I can talk about football. It's breaking the plane. That's all it is. Doesn't have to be erect. Just barely penetrate whatsoever. I think that video in itself is sufficient for you to convict of that. But Mr. McKenzie tells you he went back and did it again. Would he have kept trying if he wasn't successful? And then he said, we talked about it the next day. And he acknowledged that he'd penetrated her. So let's talk about Jabor and McKenzie. They want to make a big deal out of him not being in the photographs. Well, because he was taken. And what do we know from the evidence, Mr. McKenzie? He's no angel. I'm not saying he's not in the wrong, but he didn't touch her. You didn't hear him say anything on the video. You didn't hear Mr. Prelude say he ever heard him say anything. And he went in and out of the room. Now, he came back, but he went in and out of the room, so he wasn't even there the whole time. And he told you, yes, I lied. We tried to stick to our stories. But, you know, they say you must corroborate him. And that's true, because under the law, he's an accomplice. He is an aider and abetter, and the judge will tell you that. He's an accomplice. He was there assisting, offering to assist. He was taking photographs. He was participating just like all these guys were. So let's look at what it's required. This is what is required to corroborate an accomplice. Yeah, he could have said, you know, you could have somebody come out and say, I did this armed robbery and Governor Haslam was out in the car driving for me. You couldn't convict Governor Haslam unless you saw him on video or somehow you connected him to the crime. So there must be some corroborative evidence fairly legitimately tends to connect the defendant with the crime charge. That's all that's required. Evidence that connects him to this crime. Surveillance video is enough showing him going in a room. That's it. But you've got so much more. Videos, photographs. I'm not going to show them, but you know, to say that we can't corroborate his testimony is not what the law requires. Let's look at a little bit of what corroborates his testimony. Well, the video, obviously. You see Mr. Batey live and in color doing his thing. Photographs corroborating, showing all the various sex acts that he committed. Surveillance video corroborates him, showing him coming and going and all the various things. Mac Prelude corroborates what he said. Remember, Mr. Prelude talks about, we're going to F the bitch. He heard the same thing Mr. McKenzie testified to. He heard the same statement by Mr. Vandenburg that he couldn't get an erection. He heard those. He heard the porno playing. He heard all of that. That corroborates what Mr. McKenzie was saying. And also condoms. He acknowledged there were condoms in the room. They belonged to Mr. Vandenburg. Dylan Vanderwall corroborates the fact that he saw the buttocks very red from being slapped. He also corroborates the towel over the surveillance camera, which obviously you saw on video too. Text messages of cover-up. He says, we got together the next day and we all get together at Popeyes and talked about what we were going to do. Now, Mr. Batey wants you to believe, oh, I was just stressed out. I didn't bother to look at those photographs of that video, and they told me I should just stick to this story, and I just didn't know what was going on. So I was just texting those messages saying, does she know? Is the video deleted? All those things. Like he was just upset. He didn't really know what he was talking about. Fingerprints, of course, on the condoms corroborate Mr. McKenzie that they were passed around. He touched it. Mr. Banks touched it. There was another fingerprint that was smudged because the other two were on top. Computer search, forensic computer search verifies porno was played during the time of the attack. And the urine. There's no proof he urinated. Well, you heard the two identification police officers both testified strong odor of urine in that room when they got in there, even though it had been cleaned up. You heard the testimony about her hair. It was matted. It looked like it had been wet. So that was corroborated also. Talked about criminal responsibility, and it's simple. If there's ever been a clear case of 4 people in a crime together, it would be this one. They were almost like a pack of wolves in there doing their thing. But what does criminal responsibility require? It requires an intent to promote or assist the commission of a crime or share in the benefits or results of that crime. And then the person solicits, directs, assists, or even offers to assist, and they're guilty. Is there any question Mr. Batey was an active participant in this crime? He took her clothes off, that's clear from the photographs. The DNA on the blouse. That's enough. He did all other kinds of things. And did he get a benefit from this? Of course he did. You heard them in there. They're all having the time of their lives. Yeah, he definitely got a benefit. The results of this. So there can't be an issue as far as criminal responsibility. Each person in that room is criminally. Now, I think if you look at the evidence closely, you'll find that Mr. Vandenburg had a plan for sure that night. He told Mr. Quincy what he was going to do. So he had a plan. Did he drug Miss Lackey? He couldn't prove it because of all the time involved. But you heard a lot of circumstantial evidence, the blue drink. And then what happens when it's going on? They start slapping her, and he says, she's not going to wake up. He knows she's had 4 drinks. How could he know she wouldn't wake up? And then he goes in the bathroom, and he says, I've done this before. And in the way she felt, she'd never felt that way before. It's true, because of time lapse, the drug was there, we didn't find it. But it doesn't have to be there. It does not matter, because she was unconscious. It doesn't matter how she got there. But I think Mr. Vandenburg was planning to go to her apartment, and she got unconscious on him too quick. And he got there, found her roommate was there, still up with a friend, probably looking at the lights and things, and he decided, I can't go here, so he leaves her shoes out there. Here you go, what the evidence could show you. So where does he go? Back to the dorm. And that's when the perfect storm happens, where he meets up with these 3, the crime is committed. Sometime between 12 and 1 o'clock. Having a great time. Enjoying life. Looking forward to her future. That's Elizabeth. Thrown out there, clearly like trash. And who took that picture? That's Cory Batey's phone. Whose food do you think that is laying there? You think he put his food down, take a picture so he could remember all the fun he'd had that night? Piece of trash. Now, has waited almost 3 long years for justice. She had the courage and the strength to come in here and tell you, testify what happened to her, and you saw her. I'm just asking you to have the strength and the courage to follow your oath and apply the law to this evidence. If you do that, justice will be done. Thank you.
All right, ladies and gentlemen, do you want to take a break? This is a somewhat lengthy charge. There are a number of counts or charges in here that are duplicates, and I'm not going to read through those a second time. All right?
Hate to do this, but there may be 1 page missing.
Okay, please.
Thanks. 4208 character charge.
Okay.
It should probably be for someone else to fit the testimony. No, there's no
First page of the screen.
You got it, okay.
You guys good on this?
This
Real good. You got it right there. Just acknowledge the drinking there.
Yeah.